Mr. Murali Pillai.
Mr. Speaker, sir, I would like to first declare my interest as a lawyer who issues compliance advice on anti-money laundering and countering of financing of terrorism matters from time to time. Singapore's position as a major financial hub brings with it greater exposure to transnational economic crime. To counteract this, Singapore has developed and implemented a robust anti-money laundering and countering of financing of terrorism framework to target, prevent, and confiscate the proceeds of crime, particularly within the financial sector. And the Honourable Senior Minister of State had mentioned some aspects of it in his earlier speech. This House, as recently as in October last year, passed the Serious Crimes and Counter-Terrorism Bill to strengthen our ability to detect and deter criminals. Apart from the financial sector, other designated non-financial sectors such as pawnbrokers are also subject to AML/CFT measures. However, we are only as safe and strong as our weakest link. The Financial Action Task Force, in its evaluation of Singapore's AML framework in 2016, has identified the precious stones and precious metal dealers, PSMD, sector as a risk area for controls to be improved. The PSMD sector in Singapore is not currently subject to any specific AML/CFT controls. This is a gap that criminals may exploit and may even be presently exploiting. The PSMD sector is particularly vulnerable, as identified by the Honourable Member of Parliament, Mr. Christopher D'Souza, because of the fact that precious stones and metals are easily transported, concealed and converted to cash. This can be used by criminals to launder monies to hide the illicit sources of funds. The case of an errant lawyer in 2006 is a good example. He had used approximately $2 million that he held on trust for his client to purchase various pieces of jewellery and precious stones from a jeweller and absconded with all these items. The payments were first made by way of a telegraphic transfer from his firm's client account, and subsequently a cash cheque was issued in the name of the firm's client's account. His client subsequently tried to recover their losses from the jeweller via civil action before the Singapore courts. In doing so, the clients alleged that the jeweller ought to have known from the circumstances of the transactions that he was using monies belonging to another in breach of trust. The Singapore Court of Appeal, in a 2010 decision, considered that whilst there were some circumstances surrounding the transaction which arguably might have given rise to raise cause for concern about the probity of the transaction, the jeweller did not cross the boundaries of reasonable commercial conduct in relation to the first transaction paid through telegraphic transfer of monies. In arriving at its decision, a key consideration of the Court of Appeal was that there were no pre-existing practice of jewellers questioning customers on the source of funds, such that it would not be fair to criticize the jeweller's staff for their failure to query the source of purchases funds. The Court of Appeal comments in this regard were particularly pertinent and exemplifies the gap in our present regulatory scheme. It said, and I quote, "Clearly, it is not the usual practice for jewellers and retailers in general to ask their clients searching questions about the source of funds. As rightly pointed out by the judge, indeed there are usually cogent reasons for not asking questions. Genuine clients would feel offended, the transaction might be unreasonably delayed, and costs incurred. Admittedly, in certain type of commercial transactions, there might well be a practice of exercising due diligence. In Singapore, unlike the United States and the United Kingdom, there are currently no rules that require jewellers, gem dealers, and precious metal dealers to implement anti-money laundering programs. That is why the judge quite correctly remarked that most honest retailers would not bother to check on the background or standing of their customers, even for very large purchases. There is simply no general practice of making inquiries, and imposing such an invariable requirement on such large transactions which might jeopardize completion of a large numbers of legitimate transactions. If a jeweller in question had been required to conduct due diligence checks on the source of funds, perhaps this unfortunate matter may have been prevented. I welcome the Act, which would shore up our defences against financial crime. I also applaud the fact that the Ministry of Law had conducted public consultation, incorporated the feedback into the bill that is being introduced in the House today for the second reading. I take the opportunity to make a few short comments on the proposed Act. First area concerns how the Ministry intends to ensure that the jewelers, bullion traders, jewellery wholesalers and retailers, auctioneers and second-hand goods dealers who would be regulated dealers under the Act would be adequately equipped to understand their obligations under the Act, such as their obligations to conduct customer due diligence, CDD, and filing of suspicious transactions reports, STRs. These dealers are drawn from a wide variety of backgrounds, and they may be tradesmen who may not be familiar with or have experience in carrying out AML controls, or whose current business models will need to be adapted to allow such controls to be implemented. What are some of the steps that the Ministry has taken or plans to take to ensure that regulated dealers will have the necessary training and will be well versed with their obligations under the Act and understand the consequences of non-compliance? Next, it should also be noted that PSMDs are generally not as well resourced as banks. Would the Ministry be providing support to enable PSMDs to build capacity to conduct CDD? In comparison, I recall it was announced that the MAS was working with the banking sector to develop a common screening platform for CDD purposes. This has a salutary effect of ensuring common standards as well as ensuring that compliance costs are kept in check. Next, I also wonder whether the Ministry would be, I wonder how the Ministry would deal with possible situations arising where purchasers would spread their purchases with PSMDs to escape detection by transacting below the threshold amount of $20,000 so as to escape CDD requirements. What expectations would be placed on PSMDs to find out whether such multiple purchases were or will be made? It may not be practical to require PSMDs to share information of purchasers' identities with their competitors. But on the other hand, there could be scope for pooling information amongst affiliated PSMDs or outlets of the same PSMDs. I welcome the Honourable Senior Minister of State's clarification on this. Finally, Section 18 of the Act requires a regulated dealer to keep prescribed documents and information for a prescribed period of time. The bill does not specify what this period of time is, save as to say that the different periods may be prescribed for different classes of regulated dealers, different types of designated transactions, or different documents and information. Presumably, these requirements will be specified through secondary legislation. Could the Honourable Senior Minister of State please provide some guidance as to what the prescribed period of time would likely to be? Would this be like, for example, 5 years, as in the case of pawnbrokers? What are the considerations behind the need to segregate the prescribed period based on different classes of dealers or transactions? Notwithstanding my queries, I support the bill.